Understanding basic legal terms so that you can understand the more complex ones too. A very helpful viewer wrote in response to one of the UFLTV Utah Legal Terms Glossary video series how grateful she is for the series. She wrote, quote, "I think it's vastly underestimated just how far down to the basics so many people need help with and how ridiculously hard it is to find just the basic legal definitions or comparisons when you don't know where to look," close quote. She talked about how difficult it is to understand the meanings of legal terms, particularly how they compare to each other and what they mean in context. She gave this example, quote, "Summons, complaint, pleading, motion, judgment, and order. Is a complaint a pleading? Is a motion a complaint? Is it a pleading? Can these terms be used interchangeably? Is it sometimes one and sometimes another? Is a petition an action? Are specific motions an action? Is an objection an action? Is a motion to enforce an action? Proceedings, hearings, and trials, judgment versus orders," close quote. We agree with her. It's easy to confuse legal terms even if you know the individual definitions. So let's start with her questions and answer them in a Utah family law context. The definitions are taken from Black's Law Dictionary unless otherwise indicated. We'll start with summons. What is a summons and what does it do? A summons is a notice requiring a person to appear in court as a juror or witness, a writ or process of commencing the petitioner's action and requiring the defendant to appear and answer. A process is thus a summons or writ, especially to appear or respond in court, also termed judicial process or legal process. So when we talk about, quote, service of process, close quote, what we mean is the formal delivery of a writ, summons, or other legal process, pleading, or notice to a litigant or other party interested in the litigation. A process server handing someone a summons and a copy of the complaint or petition is, quote, service of process, close quote. Process is so denominated because it proceeds or issues forth in the order to bring the defendant into court, to answer the charge against him, and signifies the writs or judicial means by which he is brought to answer. Process and writ or writs are synonymous in the sense that every writ is a process. A writ is a court's written order commanding the person to whom it is addressed to do or refrain from doing some specific act. What is an action and what does it do? It is a civil or criminal judicial proceeding, especially a lawsuit such as a divorce case. A case is civil proceeding, action, suit, or controversy at law or in equity between opposing parties. An action has been defined to be a proceeding in court which, if conducted to a determination, will result in a judgment or decree. The action is said to terminate at judgment. A cause of action is a state of facts giving rise to one or more bases for suing, a factual situation that entitles one person to obtain a remedy in court from another person. What is a complaint and what does it do? The initial pleading that starts a civil action and states the basis for the court's jurisdiction, the bases for the plaintiff's claim, and the demand for relief is a complaint. In some states, this pleading is called a petition. What is a pleading and what does it do? It's a formal document in which a party to a legal proceeding, especially a civil lawsuit, sets forth or responds to allegations, claims, denials, or defenses. The main pleadings in a divorce case are the complaint and the answer or answer coupled with a counterclaim. A counterclaim is a claim for relief asserted against an opposing party after an original claim has been made by that party, especially a respondent's claim in opposition to or as a set-off against the petitioner's claim. What is a motion and what does it do? A motion is a written or oral application requesting a court to make a specified ruling or order. Frequently, in the progress of divorce litigation, it is desired to have the court take some action which is incidental to the main proceeding, getting to the final judgment, such as imposing temporary orders of child and or spousal support, or appointing a custody evaluator or private guardian ad litem, etc. Such action is invoked by an application less formal than the pleadings themselves and is called a motion. Filing a motion usually means that you're asking for a hearing on the issue or issues raised by your motion, but not all motions need to be heard orally. What is a judgment and what does it do? A judgment is a court or other tribunal's final determination of the rights and obligations of the parties in a case. Also, the act or action of making such a determination. The term judgment includes an equitable decree, like a divorce decree, and any order from which an appeal lies. What is an order and what does it do? An order is a command, direction, instruction, or determination of the court arising in an action. Sometimes orders do not dispose of the merits, but adjudicate a preliminary point or direct some step in the proceedings. While an order may under some circumstances amount to a judgment, they must be distinguished owing to the different consequences flowing from them in the matter of enforcement and appeal. Rulings on motions are ordinarily orders rather than judgments, which dispose of the case entirely and finally. That's what a judgment does, as opposed to just a ruling on a motion. What is a proceeding? Proceeding has two distinct meanings. A proceeding first is the business conducted by a court or other official body, such as a hearing or a trial. And the term proceeding may include in its general sense all the steps taken or measures adopted in the prosecution or defense of an action, including the pleadings and judgment. What is a hearing and what does it do? A hearing is a judicial session, usually open to the public, held for the purpose of deciding issues of facts or of law, sometimes with witnesses testifying, and where oral argument is typically made. What is a trial? A trial is a formal judicial examination of evidence and determination of legal claims in an adversary proceeding, me versus you. Any lawsuit hearing at which evidence is introduced. A bench trial is a trial before a judge without a jury. The judge decides questions of fact as well as questions of law, no jury involved. In all divorce cases in Utah, and in every other state except Texas actually, trials are bench trials in divorce cases. Are hearings and trials the same thing? No. Is a complaint or petition filed in court to commence a lawsuit a pleading? Yes. Is a motion a complaint? No. A complaint or petition commences a lawsuit. A motion is a request for a specific ruling or order in an ongoing lawsuit. Is a motion a pleading? No. A motion requests an order from a judge in short order, and that includes citation to evidence and makes argument based upon legal authority. A pleading can include requests for relief, but does not necessarily need to do so. And a pleading is not seeking immediate relief, as does a motion. A pleading can also include a formal appearance of a party, a respondent's answer to a complaint also. Is a petition an action? Not quite. A petition is filed with the court to commence an action. Is a motion an action? No. An action is a lawsuit. A motion is a request for relief made within an ongoing lawsuit. An action for divorce is commenced by filing with the court a petition or complaint for divorce. Within the divorce action, a motion for temporary orders of child custody or support or temporary spousal support or other such things can be made without the lawsuit being completely disposed of or determined until after the court rules on the motion. Is a written objection an action? No. In Utah, an objection is essentially, if not technically, a special form of motion by which a party to a divorce seeks to have a domestic relation commissioner's decision overturned by the judge. Is a motion to enforce an action? No. And by now you should start to understand that motions and actions are two distinctly different things. They may have some similarities, but they are not the same. A motion to enforce court orders is filed in a divorce action in a particular form of motion by which one seeks to use the court's enforcement power to compel a disobedient party to comply with the orders of the court. For example, if the decree of divorce requires the parties to meet at 7 p.m. to exchange custody of the children, and one of the parties is always late, the compliant party could file a motion to enforce that part of the decree by asking the court to fine the disobedient party, jail the disobedient party, and award attorney's fees against the disobedient party for the costs incurred in having to file and prosecute the motion. Is a proceeding, singular, different from proceedings, plural? Yes. A proceeding can mean several different things in a legal context, as I've already alluded to previously. Proceeding is synonymous with a legal action, for example. A proceeding can mean some action taken by the court in ongoing litigation. For example, a hearing, a case management conference, and pretrial conferences that are held in an ongoing divorce case are often referred to as a proceeding or proceedings. Judgments versus orders. The main difference between an order and a judgment are: an order is a directive issued by a court outlining the specific actions that must be taken by one or more parties in a legal case. A judgment is a decision made by a judge or court determining the rights and obligations of the parties involved in a legal case. A judgment is a final decision regarding the underlying issues in a cause of action. An order is a final decision regarding a procedural question or issue collateral to the issues in the underlying divorce action. An order is a separate document that a judge signs, which sets forth the judge's ruling on a motion. A judgment is a document that a judge signs and sets forth the judge's ruling at the end of an adversary proceeding. For those of you who listened until the end, congratulations. This is kind of a dry subject and not the easiest or most entertaining to follow. But for those of you who did follow or did your best to follow along, you have a far better knowledge and understanding of some of the most basic terms that you will hear over and over again in the course of your or your friends' or loved one's divorce action. And that kind of knowledge is power.